Affirmative Action by Jordan Perkins, Jodi and Liz Torres.
Our first court case was the U.S. versus Virginia Military Institute. This case was decided on Wednesday, June 26, 1996. It went through the Fourth Circuit Court and then to the Supreme Court. The decision was that both programs offered substantial comparable education benefits. The majority opinion was written by Ginsburg and joined by Rehnquist, Stevens, O'Connor, Kennedy, Scouter, and Breyer. The case was a win for the liberals, and the constitutional question being asked was, does Virginia's creation of a women's-only academy as a comparable program to a male-only academy satisfy the 14th Amendment's Equal Protection Clause?
Our second Supreme Court case is Grutter v. Bollinger. The case was decided in 2002 and went from the Sixth Circuit Court to the Appeals Court to the Supreme Court. The decision of the lower court was that the use of race in the University of Michigan Law School was acceptable because they have a compelling interest. The majority opinion was written by Justice O'Connor and joined by Justice Stevens, Souter, Breyer, and O'Connor. This case was a win for the liberals, and the constitutional question was equal protection being violated by the racial factor in admissions.
Our third Supreme Court case is Regents of the University of California versus Bakke. This court case was decided in 1978, and the path of the case was from California state courts and then to the Supreme Court. The decision was agreeing with Bakke, finding that the quota system explicitly discriminated against racial groups. The majority opinion was written by Justice Lewis Franklin Powell and was joined by Stevens, Berger, Stewart, and Rehnquist. The case was a win for the conservatives, and the constitutional question being asked was based on the Equal Protection Clause in the Civil Rights Act.
We're excited.